administrative and financial systems that enable the judiciary to fulfill its mandate under the Constitution. Honorable Mukaya is a purpose-driven woman leader. She has consistently focused on strengthening institutions rather than seeking personal recognition. She is resilient, disciplined with a deep commitment to building institutions that will outlast individual leadership. As a patriotic leader, she believes in leaving the judiciary stronger, more accountable, and better equipped to serve future generations. As a thoughtful communicator, Honorable Wilfrida understands the power of words to inspire, unite, and provide direction, and her skills of communications are quite top-notch within the institution. Her leadership, in terms of collaborating with stakeholders, has been seen for the last 2 years. Her style is rooted in building consensus and empowering others, recognizing that lasting success is achieved through shared purpose and collective effort. She's grounded in faith and relationships. She leads with humility. She leads with conviction and unwavering commitment to public service. Honorable Mukaya believes that an effective judiciary depends not only on sound jurisprudence, but also on efficient administration, prudent stewardship of public resources, and accountable leadership. Her progression through the judiciary has been seen by most of us within the legal profession, from frontline court service to the highest level of leadership. And the administration has given her a unique understanding of what we need as Kenya within the justice system. And her leadership has brought a lot of changes within the judiciary. As a chief registrar, she's provided strategic leadership in enhancing the judiciary's capacity to operate. She has driven judicial reforms together with the chief justice. I think basically we see her everywhere where the CJ goes. Where the CJ is, we have seen Honorable Mukaya. She's improved service delivery across the country. She's worked closely with the CJ, the Judicial Service Commission, and the NCAJ, where she plays a pivotal role in governance framework. That has enabled our judges, our judicial officers, and the staff of the judiciary to deliver accessible, people-centered, and responsive justice. I have actually summarized. Allow me, ladies and gentlemen, to ask you to be upstanding as we welcome our chief guest, the Honorable Wilfrida B. Mukaya, to the stage. Karibu sana Serge.
We can have our seats. Thank you, Ms. Christine Kungu, for the kind and warm introduction. It has been long since I was in a warm, relaxed atmosphere like this one, because many times where we sit in the boardrooms, we always appear to be in a fighting mode, and you're very, very, very serious. So even as I was coming this morning, I thought, I was wearing that face of, being very serious. I'm coming for a serious engagement. But as I got to the reception, I was told, tuliza boli. Relax. You have to be very, very intentional in terms of just taking it easy. I'm really delighted and happy to be with you this morning. Allow me to recognize, first of all, in our midst, the Commissioner, Judicial Service Commission, who is also my boss, Honorable Jacqueline Ingutia, Honorable Justice Helen Omondi, Judge of the Court of Appeal, and President of the International Association of Women Judges of Kenya. I recognize the chairperson of FIDA, Ms. Christine Kungu, all distinguished members of the board of FIDA Kenya. I recognize senior colleagues in our midst, Joyce Majiwa and Christine Agimba, senior counsel, Ms. Sophia Kaibiria, FIDA Kenya Executive Director, Ms. Betty Gashire, Director of Institute for Gender and Social Development. I think she's not here today. Let me, Sawa, thank you, I can see you there. Let me also recognize Madam Kasait, who is also here with us, all distinguished colleagues and guests. Good morning.
Good morning.
Hamjambo. Hamjambo tena. It is indeed the height of honor to be accorded this singular opportunity to address such a distinguished gathering of members of this esteemed institution, FIDA Kenya. It is both humbling and remarkable to be among some of the foremost defenders of women and women's rights in Kenya and beyond. I therefore receive this opportunity not merely as a speaking engagement, but as an opportunity to engage with women who individually and collectively have helped shape the course of gender justice in our country. I must say from the onset that the towering place of FIDA as a formidable force for women's rights is indisputable. Last year, as FIDA, you celebrated 40 years of legal aid, advocacy, and legal education. This translates to 4 decades of standing with women, taking up difficult causes, challenging discrimination, and insisting that justice cannot be complete when half of society is excluded from it. Today, FIDA is a household name in Kenya, revered and respected, but also, I dare say, feared by miscreants and potential miscreants. And I could confirm this when we were just having a small talk at the reception, when Judge Omondi dared one of her relatives that she will call FIDA on them. And the relative immediately agreed to subdivide, you know, the portion of land that they did intend to do, just because of the fear of FIDA. This institution has been led by remarkable women, some of who went on to be consequential leaders in other spheres, but I recognize that within the judiciary, we can count over 7 judges who have been mentored and directly held positions in this organization. That would include, of course include the Honorable Chief Justice, who is a life member, among others, including Justice Helen Omondi, who is here. We have Justice Mumbi Ngugi, Justice Abida Aroni, among others, who continue to serve in the judiciary. And this morning, again, Commissioner Ngutia did propose me for membership of FIDA, and I've taken up that challenge. And indeed, I will be able to register. So your leading role in securing women's rights under the Constitution of Kenya 2010 remains fresh in my mind 16 years later. As our Katiba turns 16 next Thursday, this anniversary should be both a celebration of the enormous gains we have made and a lingering reminder that some of the promises constitutionally secured are yet to be fully actualized. The 2/3 gender rule sticks out like a sore thumb as we head into the 4th elective cycle under the 2010 Constitution. It forces us to confront a difficult question. How long should a constitutional promise wait to become a constitutional reality? 16 years is long enough. The courts have gallantly stood with the Constitution on this matter. This is why the theme of this annual members' conference, Gender Justice, Digital Innovation, and Democratic Participation, could not be more timely. I see in it three distinct but intricately intertwined areas of contemporary concern. Gender justice asks whether women are able to enjoy in practice the equality and dignity promised by our Constitution. Digital innovation asks whether technology is expanding opportunity and access or creating new forms of exclusion and harm. Democratic participation asks whether women have the freedom, security, voice, and agency to influence the decisions that shape our society. The thread running through all the three spheres is the transformative leadership of women. Just 2 weeks ago, I attended a function where the Honorable Chief Justice launched a book celebrating distinguished women leaders. As I reflected on the stories of the women featured in that publication, one common thread stood out. Women's leadership is very often forged through resilience. Behind the positions, titles, and achievements that we celebrate are stories of barriers overcome, sacrifices that were made, doors that were pushed open, and sometimes battles that were fought quietly. Much of what we celebrate today as women's progress rests on the courage and scars of women who came before us. Many of us are beneficiaries of that struggle, and we occupy spaces they fought to enter. We exercise freedoms that they demanded, and we enjoy rights they insisted must belong equally to all women. Our responsibility, therefore, cannot simply be to occupy those spaces. We must use them to transform the institutions we have inherited and make the journey easier for women coming behind us. I see this transformation very clearly within our own judiciary. Today, women serve at the very highest levels of leadership in the institution. The judiciary is led by the Honorable Chief Justice, supported by the Honorable Deputy Chief Justice and the Chief Registrar of the Judiciary. A majority of the members of the Judicial Service Commission are women. And there has been, of course, the CJ has been saying this humorously, that in a few years back, the situation was not so. We had male dominating all those spaces. But when it was so, there was no complaint. And now when it is the women, there is reason to complain. However, it is our time. Across our courts, registries, and administrative structures, women serve as judges, judicial officers, registrars, administrators, financial professionals, researchers, and institutional leaders. This is significant not merely because women occupy these positions, but because women are using these positions to shape policy, reform institutions, and influence the future of justice in Kenya. We have moved beyond the question of whether women can lead. Women are leading. The question now is what transformation our leadership will leave behind. My natural inclination is therefore to speak first to the gender justice agenda and the strides that we have made as a judiciary in the quest for justice for victims and survivors of gender-based offenses. You may be aware that in 2022, we embarked on an ambitious initiative to establish standalone gender justice courts. In that year, the first standalone gender justice court was opened at Shanzu Law Courts with encouraging results. However, one of the disciplines of institutional transformation is the willingness to learn from experience, and the lessons we derived from the Shanzu pilot sent us back to the drawing board. We realized that replicating the Shanzu model throughout the country would require standalone courts with separate budgets, human resource, and physical infrastructure. This would necessitate the construction of new courtrooms, chambers, supporting facilities and registries, as well as engagement of additional judicial officers, judicial staff, and other justice sector personnel. The other real and grave danger was or is the psychological toll such cases would take on a judicial officer who exclusively serves in a gender justice court. While such a long-term and capital-intensive approach remained possible, the need for gender justice was immediate and increasingly urgent in the face of rising and evolving forms of gender-based violence. We therefore had to ask ourselves whether there was a more sustainable way of taking gender justice to every court rather than waiting to build a gender justice court in every location. Guided by the understanding of gender-based violence as encompassing acts that result in or are likely to result in physical, sexual, psychological, economic, and social harm, we broadened the scope of what constitutes a gender justice case. We recognized that gender-based harm cannot be confined to one statute, one offense, or one courtroom. We therefore moved towards identifying cases involving the use or threat of violence, coercion, abuse, or undue influence meted out on the basis of a victim's gender or sex. These reforms have now been secured through the gazettement of the Practice Directions for the Management of Gender Justice Cases 2024. The Practice Directions established a trauma-informed and victim-centered framework for the management and expeditious resolution of sexual and gender-based violence cases. This is important because justice must not merely exist in legislation or jurisprudence. It must be accessible, timely, responsive, and ultimately experienced by the woman who seeks it. The jurisdictional sexual offenses arising Amendment Bill 2026. The proposed reforms respond to the changing character of sexual and gender-based violence, including emerging concerns around technology, facilitated gender-based violence and femicide. At this point, allow me to particularly commend Ms. Christine Kungu for her leadership in chairing the NCAJ committee that has undertaken this important work. Legislative reform of this nature depends more than technical knowledge. It requires listening to survivors, understanding emerging forms of harm, bringing together different institutions within the justice sector, and translating those experiences into a legal framework capable of responding to contemporary realities. Her leadership of this process is yet another practical example of the theme that is before us today: women leading institutional change. It would therefore be a significant gain for our country if these reforms were enacted, that is, the proposals that are being made to the Sexual Offences Act. If they were enacted ahead of the next general election, particularly because election periods can heighten vulnerabilities and expose women in public life to multiple forms of abuse. Of particular concern is the emerging phenomenon of online violence. The digital space has expanded democratic participation, but it has simultaneously created another arena in which women can be intimidated, humiliated, and silenced. When in 2024, the Honorable Chief Justice spoke publicly about technology-facilitated gender-based violence directed at her, perhaps not enough attention was paid to the broader implication of what she was saying. Yet, the issue invites us to ask an uncomfortable question. How much of the online abuse directed at women in leadership is motivated not by what they have done, but simply by the fact that they are women? It is important to just think about that. Would a man occupying the same position, making the same decision, or expressing the same opinion be attacked in precisely the same way? And even where he was criticized, would the attack so readily descend into his appearance, family, sexuality, gender, or other intensely personal attributes? Criticism of public officials is legitimate in a democracy. Gendered humiliation is not, and we must learn to distinguish democratic accountability from abuse masquerading as public discourse. Research by the United Nations Population Fund has highlighted the disturbing prevalence of technology-facilitated violence against women and girls globally. As technology becomes more deeply embedded, enter the home stretch towards the next general election, this challenge requires the attention of justice institutions, companies, civil society, and organizations such as FIDA. The digital public square must not become a place from which women are driven out through fear. On the administrative front, the Judiciary and the Judicial Service Commission continue to demonstrate that gender equality must also be practiced institutionally. Apart from the judiciary exemplifying women's leadership at the highest levels, we are proud of a workforce composed of approximately 51% women and 49% men. This did not happen by accident. It is the product of deliberate policies by the Judicial Service Commission towards an equitable and inclusive workforce. Among magistrates below the age of 40, who constitute approximately 35% of magistracy, women constitute 72.2%. If those numbers tell us anything, they tell us that the future face of judicial leadership will increasingly be female. But numbers alone are not enough. Gender justice must also be experienced within the workplace. And that is why we have established the Employee Protection Unit, providing an institutional mechanism for addressing concerns, including sexual harassment, and protecting the dignity and safety of all our employees. We are equally strengthening our focus on gender inclusivity and diversity, because every person who works within the judiciary must be able to do so in an environment founded on dignity, equality, respect, and safety. An institution that administers justice must also practice justice within its own walls. We are aware that the establishment of the Employee Protection Unit, the sexual harassment policy, and confidential reporting mechanisms mark a significant step in strengthening the judiciary's workplace protection framework. However, the existence of reporting mechanisms alone does not guarantee increased reporting. As we institute preventive measures, we are sensitizing our staff on the reporting procedures, as well as concerns about confidentiality, retaliation, workplace hierarchies, and confidence in institutional progress. We are certain that this approach will boost the institutional reporting confidence, and in due course, we will have the full picture of the state of affairs in the judiciary. Having spoken about the downside of technology, allow me now to turn to its enormous transformative potential. Those of us who are in active legal practice need no sermon on how profoundly technology has changed the practice landscape. E-filing, virtual hearings, electronic case management, and digital access to court services have altered the relationship between the court and the court user. A litigant should increasingly be able to interact with the justice system without unnecessary physical journeys, costs, and procedural barriers. For women who economic, geographic, family, or mobility constraints, that transformation can be particularly significant. Internally, we have taken advantage of electronic filing and digital case management to extract gender-specific data indicators. The disaggregation of data is increasingly informing our policy interventions and resource decisions. For instance, decisions on the establishment and deployment of gender justice courts and related interventions are guided by what the data tells us about caseloads and need. We must move away from designing justice interventions on assumptions, and data allows us to ask not only how many people are accessing justice, but who is accessing justice, who is waiting longest, and critically, who is being left behind. The judiciary is also undertaking significant reforms to make justice faster, simpler, and more accessible. My office has automated the register of convicted sexual offenders to strengthen access to relevant information and support institutional decision making. Similarly, through data collection and analysis, we identified weaknesses in the processing of succession matters. The register has recorded 10,894 convictions, out of which defilement are the leading offense, followed by rape, attempted defilement, incest, and sexual assault. Nairobi records the highest share at 17%, followed by Kilifi, 14%, Murang'a, 13%, Uasin Gishu, 10%, Kitui, Trans Nzoia, Nakuru, Mombasa, Kiambu, and Makueni at 8%. However, the other day, while touring the Western region, we were informed that Vihiga now is recording the highest number of cases under SGBV. This is the data that has continually informed our targeted reforms and resource allocation. The data we have has convinced us that we must diversify our approach, and we firmly believe that sexual and gender-based violence cases are a manifestation of a deep-rooted societal problem. Apart from offering legal solutions, we need to pursue partnerships that will enable us address the social perspectives. And we have, for instance, had engagements with several county governments to build rescue centers, while at the same time making use of our court users committees as sensitization and advocacy forums. And we want to invite FIDA to partner with us on this front. Other areas in which we would be honored to partner with you are on alternative justice systems and mediation. We recognize FIDA's years of experience in ADR and legal aid, which I am certain the broader administration of justice would benefit from. Turning to succession matters, in the principal registry, we have introduced new timelines for the processing and issuance of letters of administration, with the process now targeted for completion within 60 days. This is a direct result of improved efficiency and streamlined process within the registry. Data informed the automation of the principal registry and its linkage with the government printer. Similarly, the small claims court in Nairobi will become real-time effective 1st September 2026, with a commitment to deliver judgments and rulings within 60 days. We have also addressed the long-standing challenge of delayed decrees by automating the process end-to-end from the determination of the matter to the issuance of the decree. These reforms are particularly significant for women because women are among the greatest beneficiaries of the small claims court, because many of the disputes handled there involve everyday economic and commercial transactions that directly affect livelihoods, businesses, and household welfare. For women, entrepreneurs, traders, and small business owners, speed is justice. A delayed judgment or decree can mean delayed payment, disrupted business operations, and loss of income. By leveraging technology and redesigning our processes, we are ensuring that justice is not only accessible, but also timely, predictable, and responsive to the realities of people's lives. There are women also, when we talk about digital exclusion, there are women without smartphones, reliable internet, affordable data, or sufficient digital literacy. If we digitize justice without preserving assisted and human pathways to our services, we risk replacing one barrier with another. Technology should remove the distance between women and justice. It should never become another wall that they must climb. I want to assure you that we are alive to the risk of digital exclusion, and this is why the judiciary desks at the Huduma centers had been conceptualized to mitigate, in addition to the ICT support desks in stations across our courts, as well as the Judiciary Call Center. And we still continue to welcome your proposals on that very subject of digital exclusion. Let me turn to another area that is admittedly not my forte, but which concerns me and concerns all of us as citizens of this great republic, and that is democratic participation. The dilemma that is confronting many women aspirants is stark. Do they enter a political arena whose rules, culture, and methods have largely been shaped around their male counterparts and take their chances, or do they keep away for fear of reputational, psychological, or even physical harm? We cannot claim to have an inclusive democracy if participation demands that women first develop a tolerance for violence and abuse. Just last Friday, I read a piece by Dorcas Muga Odumbe in the Daily Nation titled, "Politics Still Isn't Built for Women, Sadly." She painted a picture of a chaotic political campaign environment that leaves women aspirants constantly playing catch-up. We have all witnessed the rising culture of violence in our political space, and we must condemn it. Politics need not be unnecessarily repulsive or violent. At its best, politics is the art of persuasion, and violence has never been an argument. I strongly believe in FIDA's ability to develop and champion strategies that would enable women aspirants to participate competitively, safely, and confidently in our democratic processes. Perhaps it is time to bleach the political fabric and infuse it with enduring political hygiene. It must be our collective resolution to reject the inaccurate adage that politics is a dirty game. If the game has become dirty, our response should not be to keep women away from it. Our responsibility is to clean it up. And women must not merely be given seats at the table, they must have a voice at the table, and that voice must carry influence. As I come to a close, I have noted from your well-curated program that you have lined up a timely discussion on wellness. This is another emerging area that must go hand in hand with legal care and institutional support. As the judiciary, we have identified psychosocial support as a key need for judicial officers and staff handling gender justice cases. Repeated exposure to traumatic testimony, violence, and human suffering inevitably carries an emotional and psychological cost. Members of FIDA, as advocates and often first responders to women experiencing violence, equally require this kind of care. We must normalize the proposition that those who care for others must themselves be cared for. There is another dimension of care that we owe one another as women, and that is intergenerational leadership. That is because many of us who are here, we are here because somebody opened a door for us. Someone mentored us. And indeed, I'm in the midst of many of my mentors, talking of Judge Helen Omondi and Commissioner Ingutia. Someone mentioned our name in a room where we were not. Someone trusted us with responsibility before we were entirely certain that we were ready. And someone simply said, give her a chance. Our responsibility is to do the same. Mentorship must go beyond encouragement. It must create opportunity, visibility, networks, and responsibility. Every woman who reaches a position of influence carries an obligation not only to perform with excellence, but to leave the ladder firmly in place for the woman coming behind her. As I conclude, I return to the generations of women upon whose shoulders we stand. We occupy spaces they fought to enter. We exercise freedoms they demanded, and we enjoy rights they insisted must belong to equally to all women. And we owe them more than gratitude. We owe them progress. Maya Angelou reminded us that each time a woman stands up for herself, she stands up for all women. So let us stand up for ourselves and for one another. Let us stand up for gender justice that is experienced rather than merely promised. Let us stand for technology that includes rather than excludes. Let us stand for democratic spaces in which women participate without fear. And let us stand for the women coming behind us. Our generation inherited the struggle for women's inclusion. The next generation should inherit the freedom to lead. Let us build a country where the young women, our daughters coming after us, do not have to ask whether they belong at the table, because they will know that they do. They will take their seats, they will speak, they will lead, and the room will listen. Thank you all for your kind attention, and God bless you.
Indeed, thank you so much. I think we can clap better, even when I'm still seated. My take home was when a woman stands up for herself. Finish? Were we listening? When a woman stands up for herself, she stands up for all of us. Thank you so much. That was quite insightful. At this juncture, I want to acknowledge our sponsors.